Hello, everyone. Welcome to another episode of the U Talk Show. I am Kyle. This is Horst. And today we have a very interesting question as part of our ongoing Justice Week episodes. And that is, why do courts refer to previous cases instead of the law? Horst, why do they refer to previous cases?
Because the law doesn't cover every possibility. So I've just prepped
Interesting.
myself for this episode of Justice Week by listening to Sydney-based dance group Justice Crew, uh, um, because it seemed appropriate. But this
Hmm.
is this is a topic close to my heart because we cover the doctrine of precedent. And it's a fun one.
You know
So
that Dragon Ball Z abridged thing where Gohan is explaining something very complicated, and then Piccolo's just like nerd. I'm
so
sorry, that came to my mind when you said that this is dear to your heart. I'm
that's
just thinking.
okay. That's okay.
I mean, it's not wrong, but
So
you know, yeah.
I'm going to start this by saying that for everywhere there's an ambiguity, I am referring back to the State Library of New South Wales, which has an excellent introduction to how the courts work. Um,
Hmm.
it's almost as good as our previous video. Um, the doctrine of precedent is a rule that a legal principle established by a superior court should be followed in substantially similar cases in that court and in other courts. The idea is that you don't have a judge who wants to be seen as tough on crime. So when you go before the courts for holding up a grocery store and everyone like you has done 18 months, you don't suddenly get slammed with a 6-year custodial sentence. It's to promote consistency and to make sure that people do have a rough idea of what they're going to have to handle in court. There are two types of precedent: there's binding and there's persuasive. We discussed this briefly during
What's the
Civics Week. A
difference and
binding
how does it
precedent,
work? Sorry, yeah, go
yeah.
on, go on. Yeah.
No, this is what we hit in Civics Week, right? A persuasive precedent is a precedent that was established in a court that is not higher in the hierarchy than the court hearing the matter. And this says that, you know, these people are judges, they're appointed judges. You should probably listen to them. But a judge hearing a matter where there is a persuasive precedent has some latitude to apply their own understanding of the law and the facts and what is right to the case. Uh, I described the binding precedent as instant court of appeals fuel if it's not followed. I think there's, are you actually a moron? A binding precedent means that a court that was higher up than you in the hierarchy of courts has heard a case substantially similar to this and found this thing, and that means that this thing is broadly applicable. Going back to our
So whether or not
set
it's
of people
binding,
robbing convenience stores.
yeah. So whether or not it's binding is determined by basically by the place in which um, the place in the hierarchy of courts in which the court that is hearing this particular matter is versus where in the hierarchy of courts the previous decision was made on a substantially similar matter.
Yes.
Okay. So if one was made at like a state level court, or a district court, that would be for a local court for a substantially similar case, that would be essentially binding, but for, say, a federal level court, that would be persuasive, was the term.
Yes, that's correct. And for instance,
Okay.
if a matter has gone before the Supreme Court in Victoria, and a similar matter was heard in the Supreme Court in New South Wales, because those courts are of equal standing, the precedent would only be persuasive, not binding. I'm
Okay.
just quickly pulling up section
So
19
it's
of the Crimes
persuasive if
Act.
it's equal to or lower than, but it's binding if it's higher than. Correct?
Yes, that's
Yeah.
correct.
Okay. So that makes some sense. Interesting. And so they refer
So
to
I'm just
all of that
quickly,
in order to keep consistency.
yes, but also because, and this is the fun bit, right? I am just pulling up the Crimes Act 1900. I've referred to murder as an example of a crime because I don't think there's anyone who's going to really argue that it isn't. Um, I understand that there is some variance on how people feel about illicit drugs, for instance. Murder is pretty uniformly seen as bad. Um,
Hmm.
this is what the Crimes Act says about the punishment for murder. A person who commits the crime of murder is liable to imprisonment for life. A person sentenced to imprisonment for life for the crime of murder is to serve that sentence for the term of the person's natural life. Nothing in this section affects the operation of Section 21 of the Crimes Sentencing Procedure Act, which authorizes the passing of a lesser sentence than imprisonment for life. This section applies to murder committed before or after the commencement of this section, so all murders throughout history. This section does not apply where committal proceedings were instituted against the convicted person before the commencement of this section. Nothing in this section affects the prerogative of mercy. So, just from reading that section of the Crimes Act, we have learned that a judge who is hearing a murder case can allow a person back into the community, or they can sentence them to life imprisonment. And if we refer to the Sentencing Procedure Act, if by provision of an act an offender is made liable to imprisonment for life, a court may nevertheless impose a sentence of imprisonment for a specified term. This section does not limit discretion that the court has in relation to the imposition of penalties. So we have murder and we have these acts, and this is for New South Wales, and they're saying that a judge has a very, very wide margin of sentence that they can impose for someone who has been found guilty of murder. They can let them walk, they can make them serve 30 days in prison, they can send them to the slammer for life. Just by the law, there is not a very real there is not a very real way to predict the potential outcome of being found guilty of murder, is there?
Well, I mean, it said basically life in prison.
Mm-hmm.
I mean, that kind of.
But it also says that the court can impose a lesser term.
Hmm. Hmm. So essentially, that's giving judges discretion.
Yes, it is.
And is it up to each judge
And
exactly how
if
they
we
exercise
look at the
discretion,
case
or
law,
is that sometimes based on precedent, or how is that?
yes, it
Tell
is.
me, tell me about that. I find that interesting. Tell me about that.
Okay, so per the law, as I said, the judge has ultimate discretion.
Hmm.
Um, each judge may decide differently. You may have two sentencing hearings for murder, with substantially similar factual circumstances taking place simultaneously in the same courthouse, and one judge may sentence 10 years and another may sentence 35.
Hmm.
And by itself, that would not be grounds for any suggestion of impropriety. However, when we have a look at the bench book for sentencing, which is made available by the New South Wales Judicial Commission, I have it here, we see that there are certain agreed upon standard periods for sentencing. The three standard non parole periods are 20 years, generally, 25 years if you murder a child, and 25 years for the murder of a person falling within a category of occupation. So, for instance, if you murder an ambulance officer.
Hmm.
so the judges do have something to refer to.
Okay, so
And
they have guidelines, but
those,
ultimately the decision is with them to determine
well, it's
basically.
precedent. That's the thing.
Well, there's precedent, but they can technically break from precedent. But they do have to. My understanding is that they do have
Yes.
to provide their reasoning for that. Correct?
Yes, that is correct. Oh, Tafe taught me about this. Give me a second.
Yeah. Question: Do they have to
Ratio
provide their
decidendi.
question? Do they have to
Ratio
provide their
decidendi is the written judgment. Yeah, they have to
yeah
provide the reason that they came to the conclusion
in every circumstance, or just the ones where they
in
break
every
precedent?
circumstance, in every
Okay,
judgment.
so they
A
provide the
ratio
reasoning.
decidendi, which is the reason for the decision, it
That's
may
Latin,
refer
isn't it?
specifically to previous courts hearing this. Yep.
Yeah.
Or it may be like you may hear, let's go back to our 25 years for the murder of a kid. Let's say a judge says 40 years, then they write in their ratio decidendi, while Baldrick versus the Queen, I think it was, establishes that a standard non-parole period should be 25 years. Let's say that the child was thrown out the window of an apartment in the middle of a domestic dispute. In this case, a judge may say that due to the aggravating circumstances and the especially heinous nature of the crime, it has been seen fit to impose a larger custodial sentence.
Hmm.
And as long as that's written there, and it is written in basically every sentencing decision,
Hmm.
then that judgment
So
is
the
sound.
reasons can
And
vary
we
quite a
would then
lot.
find a similar court with a similar case may say, we're going to also throw the book at you because we have found that this is a particularly heinous crime.
Hmm. So it's kind of like yeah. So there's a lot of variation and a lot of I guess leeway for judges to um, well, essentially to make judgments about the individual circumstances of a case. Um, but there are still sufficient guidelines to, I guess, provide them. I guess to guide them. I swear I'm not trying
Yes.
to do that, but there are sufficient guidelines to actually guide them in um, I guess, very typical cases, but in atypical cases, there's sufficient leeway for them to essentially deviate from those guidelines with their judgments based on the individual circumstances of that case.
Yes.
Okay, I think that's very interesting, and that I think that's a good way to set up the system. I think it's there's strong guidelines, and yet
What it means
when
is that
circumstance
we have
deviates, it
the
allows for
average.
deviations in outcome.
Yeah. Yeah, but we have the average of the judgment of many judges informing
Mm.
future judges, which I think is a very sensible thing to have.
Yeah,
Um,
it's basically it's I guess the modern day version of the wisdom of ages past.
yes,
Wisdom of
yes.
our
And there
predecessors.
is, of course, a potential creep factor. For instance, if you have a series
Creep
of
factor.
judges who are just impose, yeah, a series of judges who, in their ratio decidendi, are um, saying that this crime is similar to previous crimes, but for the purpose of general deterrence, they have seen fit to impose uh, a slightly more lengthy custodial sentence. If you have enough of those, then the precedent generally shifts. And we may find that in 2011, it was determined that 20 years generally for a murder was a goodly amount of time. We may find that in, say, 2041, that may turn into 23 years or 24 years based on
Hmm.
a series of judges over time saying this isn't quite satisfactory.
Hmm.
Um, so
Okay,
yeah,
so
like
that even
it
allows for the
it
system
evolves and
to
shifts.
adapt. Yeah, it evolves. Like I was going to say, it adapts to the circumstances of the society that it's in, almost like a living organism,
It's a good way for a legal
evolving and
system to
shifting.
exist because what we covered during Civics Week was that the law has to pardon me, the law has to describe the social mores of its environment. The law cannot be significantly at odds with what is considered socially acceptable.
Interesting. Interesting. All right. I think that's a very interesting note to end it on, unless you'd like to say something more.
There is one more thing I'd like to say, though it's mainly a footnote for the nerds and for you, Kyle, specifically. Um,
Yep.
there was a computer game in the 80s where you were given a number of cases to read up on, and the aim of the game was simple: decide a suitable sentence. And your performance in that game would be compared to what the real judges who had heard those cases decided. Um, the fun bit is that if you had copied the game illegally, it had rudimentary copy protection. The game would switch into a mode where the only case you heard was for the crime of software piracy, and the only sentence given was the death penalty.
Oh, that's good. That's good. That's good.
Yeah! Thankfully,
Screw
software
that. I'm a
piracy does
pirate.
not carry the
Arr.
death penalty in Australia.
Yeah. I'm still gonna be a pirate.
I'll
Arr.
try and find you a link to that game later. I just figured you'd
Oh,
enjoy that
please do.
conceptually.
Please. No, that's pretty good. All right. Well, with that, we'll end it. Thank you for watching. I hope you
And
found this
we'll
as
see you
interesting
all
as I did.
tomorrow.
See you then.